On the request made by a number of students, I would like to discuss the jurisdiction of the Magistrate's Court in this video clip. The provisions of the Criminal Procedure Code as well as the Judicature Act deal with the jurisdiction of the Magistrate Court. First of all, I think better to study, better to understand the definition for the terms of expressions given under Section 2 of the Code of Criminal Procedure Act. Generally speaking, we can say Criminal Procedure Code, but when you write in the examination, you must say Code of Criminal Procedure Act. That's the correct name. Now we will see here the bailable offence means an offence shown as bailable in the first schedule to the Code of Criminal Procedure Act, or which is made bailable by any other law for the time being in force. As you know, there are certain legislation restricting the grant of bail. For example, Section 10 of the Offensive Weapons Act provides that no person charged with an offence under Offensive Weapons Act shall be released on bail except on the order of the Court of Appeal. Likewise, another example we can discuss here, the Prevention of Terrorism Act provides that the Court of Appeal may, in exceptional circumstances, release on bail. But when you see the Bail Act, granting bail is the rule. Refusal to grant bail is an exception. Then we will move for the definition of term of expression. Complaint means the allegation made orally or in writing to the magistrate for the purpose of taking action under Criminal Procedure Code that some person has committed an offence. Discharge means discontinuance of criminal proceedings against the accused, but it does not include an acquittal. Acquittal in the sense totally discharged. The person who has been acquitted cannot be charged again on the same facts. But the person who has been discharged, there is a possibility to be charged again on the same facts. That's a big difference between discharge and acquittal. Then we will see the offence. Offence means any act or omission made punishable by any law for the time being in force. There should be a very express provisions in the law, and the law should provide that is an offence. Then summary offence means the offence triable by a magistrate court. The Judicature Act, Section 30 of the Judicature Act, given the general power to the magistrate court. When you read the section here, every magistrate's court shall have and exercise all the powers and authorities and perform all the duties which the magistrate's court are empowered and required to have exercise and perform by virtue of the provisions of the Penal Code and Criminal Procedure Code, and also any other enactment for the time being, in any way empowering or requiring them in that behalf. What we have understood by this section empowers the magistrate to conduct summary or non-summary inquiry, to take steps to prevent the commission of an offense, and to assist criminal investigations. Now we will come back to the Code of Criminal Procedure Act. Magistrates' court shall have the power and authority to hear, try, determine, and dispose of in a summary way all the prosecution for offences which by this court means Criminal Procedure Code, or any other law in force are made cognizable by a magistrate court. The cognizable offences means an offence for which the peace officer may, in accordance with the first schedule, arrest without warrant. Generally, summary in the sense there are some offences given in the penal code, as well as there are so many offences given in other legislation. We must see whether the power is given to the magistrate court. If the power is given by any other laws, then the magistrate court has the jurisdiction to hear and dispose the actions or the offences. Further, magistrate shall have so many jurisdictions. The first one, inquire into all offences committed or alleged to have been committed. Inquire into or to summon or examine all the witnesses and issue warrants to arrest a person or other processes to apprehend and summon all the criminals and offenders and deal with them according to the law. There are offences the peace officer can arrest without warrant. There are offences peace officer can't arrest without warrant. If there's an offence committed before the peace officer, then peace officer can arrest such person without warrant. That's an example here that I would like to say. Then we will see some more power or jurisdiction given to the magistrate to issue warrants to search or to cause to be searched all the places wherein the stolen goods or whatever is there. Then the thing is here, there is a suspected place. There may be stolen goods, there may be a person hidden under cover of some people. Then the police or the peace officer must get the warrant, search warrant, and go and search a place. And require the person to furnish security for the peace. Under section 81 of the Criminal Procedure Code, if there is a breach of peace, then that person can be brought before the magistrate. In that case, the magistrate asks him to give a security for the good behavior. Now we will see the final one. Inquire into all the cases in which any person shall die in prison or hospital, or shall come in to his death by violence or accident. This is known as sudden death. When the death have occurred suddenly, or the body of any person shall be found dead without it's being known how he has died. In those cases, there must be an inquiry. Then the power is given to the magistrate to do the inquiry. Then, at the end of the trial, especially in the summary trial, magistrate finds that the person has committed an offense, then issue the sentence. But not in all ways, because certain cases there may be community corrections orders, but not for all offenses. Where the offender is convicted for an offense other than the offense for which the imposition of minimum sentence of imprisonment is mandatory. In certain offenses, the law provides that if a person committed certain offense, he must be punished not less than 2 years, not less than 6 months. In those cases, there is a mandatory jail sentence to that offense. In those cases, community correction order cannot be issued. And the offenses, the penalty prescribed for which includes a term of imprisonment exceeding 2 years. Then, on those two cases, community correction order cannot be issued. Another one thing I would like to say here, before making a community correction order, the accused or the convicted person the offender must accept it to go for a community correction order. If the accused refuses to accept the community correction order, then the magistrate should not issue or make any community correction order. Then section 14 of the Criminal Procedure Code here, the magistrate may impose any of the following sentence. This is a maximum power or the jurisdiction given to the magistrate. The imprisonment of either description for a term not exceeding 2 years, or a fine not exceeding 1,500 rupees. Whipping, now we know that corporal punishment is totally repealed. That you can refer the Corporal Punishment Repeal Act number 23 of 2005 and any other lawful sentence combining any of two of the sentence aforesaid. Now here, when you see the power or the jurisdiction of the magistrate, especially in relation to the sentence, is only very restricted. The imprisonment not exceeding 2 years, that's all right. But the fine not exceeding 1,500 rupees. But keep it in your mind, the special power of punishment may be given by piece of legislation. In those circumstances, magistrate is empowered to impose even 1 million rupees. There are so many legal provisions in the enactments nowadays which carries more than 1 million rupees or more than 1 lakh rupees. At the same time, the power is given to the magistrate to impose such fine. Then in that case, magistrate can impose even the amount of fine, whatever mentioned in the legislation. That's why here special power of punishment may be given by piece of legislation. Then we will see here section 15 of the Criminal Procedure Code. The court shall not sentence any person to imprisonment whether in default of payment of fine or not for a term not less than 7 days. Then always the punishment, especially the imprisonment, should be imposed on accused not less than 7 days. Then 16 of the Criminal Procedure Code here, then we will see the section. When a person is convicted at one trial of any two or more distinct offences, there are maybe so many offences in one trial, the court may sentence him for such offence for several punishment prescribed therefore, which such court is competent to inflict. Then say suppose there may be A offence, B offence, then 6 months, the magistrate can impose 1 year. But there may be 2 years, then altogether 4 years, that also can be granted. But suppose ABC offence, 2 years, then altogether 6 years, that cannot be done. Because aggregate punishment shall not exceed twice the amount of punishment which such court in the exercise of ordinary jurisdiction is competent to inflict. Generally, ordinary jurisdiction is given to 2 years imprisonment plus 1,500 rupees fine. Then the twice in the sense it must be 4 years imprisonment or 3,000 rupees fine. That must be noticed here. Then we will go to section 81. Whenever a magistrate receives information that a person is likely to commit breach of peace, then as we have seen earlier also, magistrate may require such person to show cause why he should not be ordered to execute a bond with or without sureties for keeping a peace for such period, but it should not be exceeding 2 years. Then finally, we will see the non-summary inquiry. Summary inquiry, non-summary inquiry. Summary inquiry in the sense, magistrate has the full power to hear the matter and dispose of. Has the power to hear the matter and dispose of. Then the matter is over, the sentence granted or issued, the matter is over. The order is issued, the punishment given, finished. But in the non-summary inquiry, when the accused is brought before the magistrate, then the magistrate must see there's a prima facie case. That's very important. That's why this is limited to certain offences. First of all, the magistrate conduct the whole inquiry and send the file to the Attorney General Department to file an indictment in the High Court. Because these are serious offences, then it should be trialable by High Court. Then here, where the offence falls within the list of offences set out in the second schedule to the Judicature Act, not the Criminal Procedure Code. The Judicature Act, the second schedule that's listed certain offences. In relation to those offences, magistrate can do the non-summary inquiry. Where the Attorney General being opinion that the evidence recorded at a preliminary inquiry will be necessary for preparing indictment. In those two cases, magistrate must hold preliminary inquiry, and finally the matter will be referred to the Attorney General to file an indictment in the court, in the High Court. That is the end of the jurisdiction of the Magistrate Court. Thank you for listening. Thanks.